Hello, hello, hello. This is Attorney Mike Grevlin coming to you from Chicago. As usual, where the Wi-Fi usually works, I've got a fun clip. We've got a Karen sovereign citizen. She's attempting to pay her debts with her magic trust funds. At least that's what it appears. That's what it appears to be. It's pretty fun. Let's do this thing, shall we?
Council, going to call your 9 o'clock case. We are on the record and cause number DC 23-03286, Delta Victor LLC versus Lisa Irene Writing et al. May I have you to announce on the record? Let me know your name and who you represent.
Good morning, Your Honor. John Dubiel for the plaintiff.
All right.
And Lisa Irene Writing Nyber in full life, sui juris, as well as by special appearance, not generally today.
Okay, and you're representing yourself, is that correct, Ms. Writing?
I am representing the beneficiary of the uppercase name in the estate. Yes, ma'am.
Okay, and are you a lawyer, Ms. Writing?
No, I am attorney in fact.
I'm sorry, I didn't understand you.
I am a private attorney in fact.
Private attorney, in fact, what does that mean?
It means specifically that I have a private exclusive power of attorney over the estate affairs as its beneficiary, and I have a right to conduct business that is necessary, including legal matters.
Oh, sweet Jesus. What?
Okay, my question to you was, were you a licensed attorney
No,
in the
ma'am.
state of Texas?
No, ma'am.
Okay,
And it's clear of my status as well. That has been submitted to court from my very first appearance.
okay. Counsel for the plaintiff, this is your motion to disperse funds. Let me hear from you at this time.
Thanks, Your Honor. So back in August of last year, this court entered summary judgment in favor of plaintiff for $970,000 and 15% in interest per annum. In March of this year, the defendant delivered a purported check to the Dallas County registry in the amount of $1,350,000 and received a receipt for that amount from the registry of the court. And that, quote, certified funds and the receipt are attached as Exhibit A. In April of this year, the Dallas County Court and Bank of America North America.
Oh, good Lord. I didn't notice this. We're talking about over $1 million here. She really, if this is what I think it is, which is them saying, oh, I've got some magical trust and I'm going to satisfy over $1 million in debt with that. That's just straight fraud. It's criminal fraud. It's not where we're headed, but she should be held in contempt immediately. If it was me, I would hold her in contempt and set an in-person hearing so I can put cuffs on her.
Treasury Servicing and Operations exchanged a series of emails regarding the validity of that check, and the latter showed that those funds were fraudulent and recommended reissuance or wire transfer.
Yes, this is a civil action, but you can't perpetrate fraud on the court openly. And they still have contempt power, number one. Number two, she's certainly left herself open for criminal charges to be brought if this is the scenario I think it is.
In July of this year, the defendant sent another purported payment in the amount of $1,350,000 to the registry of the court. That purported payment is also attached as Exhibit A.
Mm-hmm.
In August of this year, David Bradley, who is the accounting and collection supervisor of Dallas County District Clerk, wrote an email to the plaintiff stating that the only valid payment he has received in conjunction with this case are the filing fees that I paid in March of last year. So it's my understanding that the plaintiff a representative spoke with Mr. Bradley yesterday, who again confirmed that there are no funds currently with the registry of the court. Now, although this motion is entitled Motion to Disperse Funds, it's clear there are no funds to disperse. I've also cited authority that the court has great latitude in dealing with these funds and has the equitable.
Wow, this takes guts. You do this, you do it in writing so we have proof of it to a court. You know, and then you file a motion to disperse funds when you know that it was fraudulent. Wow.
Power to make such orders as it deems necessary to protect them. So to that end, I uploaded an additional order yesterday for the court's review, which would require the defendant to make payment in the form of cash check, money order, or wire transfer. However, I'd like to strike through check, given that 2 fraudulent instruments have been submitted to the court already. And so I would ask the court to sign the order.
It's interesting having a real attorney trying to address this. He wants to cross off the word check because she's using that to make up this fraudulent nonsense. At least that's his contention, which I think is correct. And so he doesn't, he's like, these fraudulent instruments, I don't want to call them checks because they're not. That would be suggesting that there's some validity to them.
In the form uploaded, but strike through check.
All right. And did you mention that you uploaded an order on yesterday? If so, I don't see it on our system just yet, but I can go and pull it down. The last order that we have, it looks like it was uploaded on September 3rd.
I can do that, Your Honor. It was yesterday. It has been accepted. I thought that I emailed it to Miss Alonso as well. If not, I can certainly do that.
Okay. If Miss Alonso has it, then I can get it, but we'll confirm that.
Okay.
All right. Counsel for the plaintiff, is there anything else regarding your presentation?
No, Your Honor.
All right. Mrs. Writing.
Thank you for appropriately addressing me. And to correct a few items.
Any objection? All objections.
And just in summary, is I also submitted a corrected order for disbursement yesterday, and it was received as well. So you should have 2 of them there, Your Honor. Also in correcting, I did not provide a check. I also provided what is called a negotiable instrument. That negotiable instrument was against a bond and is legal tender, and it was received, and there is an official receipt.
No, it isn't. It's just that simple. She's demanding to discharge her debt with monopoly money is the simplest analogy I can give for it. That's it. It's no more complex than that.
Receipt on file for that. That was filed on 3/15, and on 3/29, the trustee and clerk of the court, Felicia, moved it directly to the plaintiff. On 4/8, you signed a order that the case was closed. As part of that process, it clearly states specifically on the receipt that it has to be held for 30 days because it could be appealed, as you know. It was only after continued trespassing was occurring by a bar member that I submitted a second payment. And I appreciate the trustee's office because they returned the second payment with a note that said tender payment had already been made. I appreciate them staying in honor. Since then, I have also filed an IRS corrected 1099-A form, primarily because the TT&L operator and the money logs, 120 logs, actually showed that the case had already been prepaid. In addition, I have done some research and requested through the Treasury directly the bond number on this case and docket. They refused, but my broker was able to find it directly. So as part of that process, the setup process may be a little bit different than utilizing a check or wire transfer as the plaintiff counsel appears. However, my packet was also submitted with a Form 56, as the fiduciary and the case trustees are mandated to file and also file Title 48. And they're also titled to do the set-offs as required and pull directly from that minor account. I have provided that in a brief of all that has been done, but that tender of payment has been accepted and received. And I instructed, even though I am not entitled to give the plaintiffs any attorney any legal advice, is to file for the disbursement as the receipt indicates he can do after 30 days. He failed to do so until about a month ago. However, he has additional bar members that are continuing to trespass on the estate.
Do I have at least 2 witnesses that they are committing treason? This is treason. They're violating my rights.
And have attempted both in Arizona as well as in Oregon to continue to garnish and also trying to collect on something that has been paid and closed since April 8th.
Miss Writing, let me stop you right there because I'm having difficulty following. What is the relief that you are seeking from this court? You just heard the plaintiff represent his argument that defendant submit funds to the registry in the court in the form of cash, money order, or wire transfer. What relief are you seeking from this court at this time?
What do you want? Lordship, my senior will not be here.
What do you want?
Lordship, another date, Lordship.
I'm just looking for the disbursement to be signed, but according to the one that I submitted. So I submitted a corrected disbursement with the accurate information on it. And I had 2 additional items in which I was asking. My order and adjudicated in decree includes that the court releases and makes disbursement of funds and satisfaction of debt to the alleged creditors. The tender of payment had already been made to the court in accord with 28 USC 2041, USC 307, 304, and 306. The court did not dishonor that tender, and therefore the tender and adjudicated claim in accordance with 2045.
Hell no.
I also asked for 3 additional elements. I asked for the case to be sealed because confidential information that the bar member failed to redact and mark as confidential will help protect me from additional identity theft because it has my social security number on it. I also asked that the bar member release ongoing harassment of Lisa Writing in the lower case, as well as trespassing on the estate. And lastly, I asked that the bar member for the plaintiff dismiss with prejudice any additional orders that he has legal action in Arizona and Oregon for garnishments. If one other stipulation here is that if the plaintiff's bar member is refusing to accept legal tender that has already been received by the court, and he's motioning to strike that I use another form of methodology for paying, I would also move to have a motion that he uses his bond to pay it rather than the bond that I was submitted.
All right, counsel for the plaintiff, brief response.
So as far as
I'd move to have a motion that he uses his fake trust instead of my fake trust. My God. Contempt. Bring her in.
the receipt that the defendant has received, that's a receipt simply acknowledging the documents that the registry of the court received in their office. There's actually been no transfer of funds, and that's been confirmed multiple times. One thing I did hear, and I don't believe any personal information has been disseminated to the court, and we certainly have no intention and will not do that. But otherwise, the defendant must comply with the rules of the court, which require cash, check, money order, or wire transfer. But again, I'm going to submit an additional order or ask the court to strike through the use the word check in the order already submitted.
All right. Anything else? Counsel for the plaintiff, since you're the movant.
No, Your Honor.
All right, Ms. Writing, anything else?
I would probably just define, if I don't want to get into semantics here, but for the plaintiff's attorney, money is defined by the UCC in accord with Section 1201-24 specifically. And I can get into an argument of what is legal tender,
You could, and you'd lose.
even down to 18 USC 8, including bonds. But I have provided all legal tender and obligations to the United States in accord with public policy. You, as its trustee, according to 31 USC 5118D 1 and 2, are required to discharge this debt. And legal tender was made at the time of payment, which was on 3/15, and closed officially on 4/8.
All right. I will review the 2 proposed orders that have been submitted to the court. I will sign an order today as it relates to the plaintiff's motion to disperse funds that will be uploaded on our system for you to view. Are there any other questions for the court?
No, Your Honor, other than should I submit a new order or no? Striking through check,
Did
the
you-
word check.
Did you mention that you had emailed also the order, the latest order to Mrs. Alonso?
I believe I did. If not, I will do it the moment we get off this hearing.
Okay, if you can double check, because again, I am going to go to our clerk. Again, the last order that I show uploaded is September 3rd. I will let them know that there should be some more orders out there. Can you pull those down and give them to me so I can review them and get one signed today?
Thanks so much, Your Honor.
All right, if there's nothing further, that concludes our hearing.
Yeah, and Your Honor, I also submitted almost an identical, but with the 3 additional items I was asking for.
Correct. And as I mentioned before, I'll be reviewing both orders, make the determination which one is appropriate in line with the court's ruling. And I will basically sign that particular order today.
Thank you.
Thanks, Your Honor.
Thank you. Take care. Bye-bye.
Bye.
Holy wow. That's messed up.
We'll have a prediction. It won't be the order submitted by her. Unbelievable stuff. They get away with so much because they're pathetic. If an attorney attempted this, they would lose their license and end up in jail immediately. But we are talking about someone who's claiming that they paid over $1 million out of their magic trust. We can't accept this. The court system has to provide a penalty for that, and they probably will. It's frustrating because it'll take a long time. The judge just sidestepped her and said, "Well, I'm going to issue a ruling later today." She doesn't say what it is. I need to thank Jude Izarita, I might be pronouncing that wrong, for sending that to me. This is old. It's like when I was looking, it was like 9 days old, but I haven't seen it before, so it was new to me, and I thought it was fun.